Hello. Okay, let's talk about just a reminder when a lawyer is commenting on social media or from their website or from a podium to a big group of people, they're generally not giving legal advice to any particular person in that audience as a general rule, because those people are not their clients and they don't give legal advice generally to people who have not retained them to be the client. I know it's probably obvious for most of you, because if the attorney doesn't know the finer details of every little nuance of your situation, which he won't unless he is your retained attorney, then obviously the information he's talking about is not necessarily targeted towards your particular situation. It's more of a generality, more of an educational, general information communication usually. So let's get into it about why this might be. The bigger reason why there are disclaimers everywhere you'll see, like on somebody's website, or for instance, behind me here, over here, it says specifically general information only, no attorney-client relationship. It seems obvious, right? And I agree, it shouldn't even have to be there. However, apparently, in days, decades, and eons past, attorneys have probably been screwed, to put it lightly, when they put out a kind word of information when someone asked for general information, and the person then took it to heart, misapplied it as behaving as their own attorney, and screwed it up potentially, and then wanted to come back to the lawyer and sue him for legal malpractice. So that's what brings, the whole current situation where lawyers have to constantly have disclaimers to clarify for perhaps the less than brilliant that this is not representation of them, it's general information. Okay, so I'm looking at a really good summary here, so I didn't want to recreate the wheel. Snyder Law Group put it out. I thought it was pretty good. They talk about the number one reason for disclaimers is to prevent misunderstandings. And they say that disclaimers help clarify that the information provided, particularly on a website or other public forum, like we're talking about, is generally information and not specific legal advice. And of course, laws can vary greatly depending on which jurisdiction you're in. Usually this would go state by state here in the United States. And of course, as I mentioned before, as per the individual situation. So that is why information for one person, or generally, is not necessarily going to apply to one person, nor would like instructionals. There can always be a cog in a wheel, particularly in our industry, when you're dealing with a government agency, a bureaucracy, the Social Security Administration, for instance. So that is something to be recognizing when wondering, but why isn't this legal advice? Or why does the lawyer need to, or feel the need to re-explain it to me like I'm a dummy? We don't think you're a dummy, but there are occasionally dummies out there. Okay. As you can see, I'm not very politically correct about it. Don't intend to be. All right. The second reason they give is to make it clear that there is no attorney-client relationship. This seems like another no-brainer, right? Obviously, but I guess there have been instances in days gone past. There's probably a lot of legal research one could find out on case law on this, where someone just assumed that even though money hadn't changed hands and no agreement was signed representing that, this lawyer that looked at him cross-eyed must now be representing him. So there you go, that disclaimer there. And one of the reasons, of course, also is to protect confidentiality, as this law group points out. If a person misinterprets a public interaction as an attorney-client interaction, they might disclose information they believe to be confidential. Now, this seems like it could never happen on social media or public forums, but apparently it can. So that is another important thing as to why we point out that we are an attorney, but not your attorney. Okay. And reason number 4, of course, is to limit liability. a person might rely on the general information, and I alluded to this before, provided by a lawyer, and then suffer harm as a result because they didn't properly apply it. They acted as their own attorney, but then want to go back and hit up the attorney, perhaps to compensate them for the damages they caused themselves by not doing things the right way and taking general information and assuming it applies to everything. Last but not least, ethical obligations. I can't speak for all bars. I can only speak generally to mine, which would be New Jersey. We have an ethical obligation to put these out there and make sure that the most confusable among us will not be confused. Okay, so as for me, that is definitely the case. But I just wanted to explain it to people who might wonder why we all smack these general information only, no client attorney relationship exists, unless you've retained me with an agreement or whatever. I think back in the day when there used to be a lot of letterhead going out to potentially non-clients, different fields than my own, I think it is, but there would be even at the a generic on the letterhead footer, they would have a little blurb down there just in case someone who's getting a letter who isn't a client suddenly just thinks for whatever bizarre reason that this is suddenly their lawyer, even though they never retain them. Anyway, that is the explanation of the constant disclaimers you see amongst and from lawyers on their websites, on social media, on video backgrounds such as here. It's just to make sure nobody who might be forgetful has a reason to forget. All right, take care now. Bye.